My name is Ibrahim Abdullahi Lawan. I am an associate partner in PSA firm, and my manager, Ms. Putri Sofia Amiruddin, have instructed me to critically evaluate the current situation, foreclosure, possession, and sale of a mortgaged property. Brendan Collins has entered into an agreement with Tough Bank, and he has failed to comply with the rules of the mortgage. Mortgage basically means security for loan. In the case of St. Lee and White, a mortgage of a real property comprises of transfer, conveyance of a legal or equitable interest of a borrower's land to the mortgagee with the provision that the mortgagee's interest shall lapse upon repayment of the loan, the interest and the cost. And in this scenario, Brendan is the mortgagor, who is the borrower, and Tough Bank is the mortgagee, who is the lender. In the case of Tromborough versus Baker, that once a mortgage is always a mortgage. The mortgagor have right to get back his property in full the moment he settles the mortgage or the loan plus the interest and the cost. In the case of Brandon did not pay back the loan on the agreed date of redemption due to his reasons. Obviously, when a mortgagor fails to redeem his property on the legal date of redemption, his right on the property will cease. This approach is a strict legal rule which is very unfair and harsh in the sight of the mortgagor. And it took away the maxim of once a mortgage is always a mortgage. The court have introduced the equitable right to redeem in order to give fairness, easiness, comfort, and to be just in the sight of mortgagors. In the situation like Brandon's, where he did not fulfill his obligation on the legal date of redemption, was not voluntarily because he has his daughter's health condition and so on, and he has so many problems. The court will have equity for him rather than being following strict common law just for his property to seize the moment he did not pay on the legal date of redemption. In the case of Swin, Hanham versus Howard, the equity of redemption is valuable and it is proprietary right which may be transferred or sold in the representation of mortgagor's right to the property. Also, mortgage is a device of security of the loan and to be redeemed once the debt is settled. Not an opportunity for the mortgagee to acquire the property. That is why court of equity stand to defend the mortgagor's right on redemption. Because a mortgagor will agree to any terms of the loan in order to get the money because he is in need. Court introduced the rule of equity to get easiness for the mortgagor. Also, mortgage cannot be made irredeemable. Pro tanto. In case of R.E. Wells, any provision of the mortgage where it include forfeiture of redemption, it is to be regarded null and void. Also, in the case of Jones and Morgan, it was stated that a mortgage must be redeemed. But where the mortgagor forfeited his right to redeem, but it has to make sure that it has not, the mortgagor did not say so under the influence of undue influence. Also, a mortgagee cannot stand a chance to buy the mortgage property or make a clause in the agreement that the property will be transferred to the mortgagee, provision will be null and void. In the case of Samuel versus Jara, the court will strike out any unconscionable bargain, irrespective of whether it amount to a cloak or fata on the equity of redemption. In Brown and Wilkinson, any term of mortgage must not violate the rule of redemption, despite all the rights and favor that law of equity have given to the mortgagor in order to balance the benefit of both parties. The equitable right of redemption will cease when the mortgagor cannot pay or settle the debt owed by him. In this situation, the mortgagee will also have to enforce his rights. Such rights include the right of foreclosure. The right of foreclosure means that the mortgagor's right on the property will totally extinguish to the mortgagee. The right of foreclosure, it means that the mortgagor's right on the property will totally extinguish to the mortgagee. The right of foreclosure is the strongest and the most powerful remedy in the principle of mortgage, which extinguishes the equity of redemption.
This is covered under Section 88 of the LPA, where it says when a foreclosure is successful, the right in which the mortgagor have in the property will be transferred to the mortgagee. The right of foreclosure arises as soon as the legal date of redemption is due. The right of foreclosure must be asked in court in order to get court order for the mortgagee to exercise the right of foreclosure. A mortgagee cannot exercise the right of foreclosure on his own unless it is granted by the court for the mortgagee to be the outright owner of the property. However, the mortgagee may promise to the mortgagor that he will not exercise right of foreclosure without notice. And in the action of applying court order, the mortgagee will begin with asking the court will begin with asking the court the right. The court will grant such application unless the mortgagor repays the debt within a reasonable period of time. If not paid within such a reasonable period of time, the mortgagee will be granted right of foreclosure nisi. The further period, the period that can be extended, it's usually given in court 6 months of time. Failure for the mortgagor to settle the payment within 6 months of the extension, the absolute foreclosure will be granted to the mortgagee, and the mortgagor will lose interest in the land. In applying this law to the scenario, Brandon may be given an extension of 6 months in the court rather than 3 months that top bank manager was giving him before the right of foreclosure may be absolutely exercised by the top bank. That is to say, Brandon have to make sure that he made the payment within such period of time that he will get the extension by the court. Under Section 91 of the LPA, other mortgagees, if not just one mortgagees, will apply for this right in the court. Even the mortgagor himself, he can apply such right in court, and he may be granted to sell the house and settle such debts when the value of the property is more valuable than debt itself. In concluding on foreclosure, as a legal associate, I would like to tell the PSA manager, Ms. Putri Sophia Amiruddin, that to balance the remedy between both parties, mortgagee and mortgagor, before the right of foreclosure can be granted by the court, bank to exercise their absolute right of foreclosure, they need to have extended the term by at least 6 months to Brandon. But after the extended term is ceased and the payment is not made, Top Bank may apply to court and they can exercise their right. The only exception to that is that in the case of McKellen versus Smith Land, it was stated that before right of foreclosure can be exercised, there is need to be refinanced. So in this case, Top Bank have refinanced to him. I don't think he has any other right as the 6 months extension. Another right that Top Bank may have in such situation is the right of possession. The essence of mortgage is to secure the loan, and for the mortgage to get a security for the money lended to the mortgagor. When the mortgagor defaults in the payment, then the mortgagee will have to exercise his power of security to sell the property in order to get back his money. Before selling such property, most likely it needs to be vacated. This right does not only happen when the mortgagee wants to sell the property, but in order to get income from the benefits of the land, to get back the money he lended, then give back mortgagor his property. However, taking possession does not mean that the right of the mortgagor to the property is seized. But if the possession is taken and right of sale is exercised, then the mortgagor will lose interest to the land. However, in the case of Four Mates versus Dudley, the mortgagee may take possession the moment the ink of the mortgage dries. In the case of Rappellet, it was stated that the mortgagee may take possession even if the mortgagor is not in default. Under Section 98 of the LPA, it was stated that if the parties have contractually promised not to take possession unless the mortgage defaulted, in this scenario, Brandon have defaulted in payment of his debt. Top Bank may claim for possession, and in any circumstance, even in Section 98, cannot cover him because he has defaulted. However, in the case of dwelling houses, mortgagors are protected by the Administration of Justice Act under Section 36 and Section 8 of the 1973. Possession of dwelling houses may be suspended or may be adjourned by the court if the mortgagor is willing to make the payment within a reasonable period of time. This rule is backed up by the case of Building Society versus Clark. In applying this to the scenario, Brendan has family, which he is claiming that one of his family is on medical condition. So, Section 36 of AJA may protect him and may give him extension to extend the time of the possession. However, in Mortgage Agency Service versus Ball, it was stated that the mortgagee may recover possession if the reasonable period is ceased and the payment is not made by the mortgager. However, in the case of Middlesbrough, it was stated that while the mortgager is not making effort to make the payment, the court cannot extend time for him after the reasonable period have ceased. In applying to this scenario, Brendan, since he is making effort to pay, it's just that he is having some difficulties. The court may give him extension and make the payment later. Now, the court may extend or suspend possession of the automatic 2 years. That is in the case of dwelling houses, in collaboration with Section 36. In order to give mortgagors reasonable time to pay their arrears, the court will try to protect these with the family residing with the mortgage property in order to balance remedy. The court can give him extension because he's in temporary difficulty. They look at his condition and they can give him time before taking possession. In the case of repayment, mortgagee must not take possession with court order. He can just take possession on his own without going to court. Lord Denning, in the case of Quinnell versus Malby, stated that the court of equity will try to stop mortgagee from taking possession without a valid or justifiable reason. And Royal Trust of Canada, the suspension date needs to be fixed. In conclusion, I will submit to my manager, Ms. Putri, that Brendan may stand a chance of suspension of possession because his property is likely to be a dwelling house and he may be protected by Nogan and Section 36 AJA. However, the mortgagee also have the right to sell the mortgaged property based on the conditions stated under Section 101 and 103 of LPA 1925. For the power of sale to be exercised, the power of sale must have arrived and must have been exercisable. For the power of sale to arrive, the provision of Section 101 of the LPA must be made fulfilled. That the mortgage must be made in deed. It's not just a contractual agreement or something. It must be a mortgage by deed. And the mortgage debt must be due. And in the clause of the mortgage, it must not exclude the right of sale. In applying rule of 101 to the case of Brendan, the court will look at the agreement they have. Is it on deed? Yes, if it is deed, then one requirement is met. Then secondly, is the debt due? Thirdly, is in their agreement, does that exclude the right of sale or include it? If right of sale is excluded, Top Bank can never sell the property of Brendan. Secondly, the power of sale must have become exercisable. The right will be exercisable when one of the provisions of Section 103 of the LPA occurs, which is there should be default in complying with notice to repay of the mortgage for not less than 3 months. The interest is at least 2 months in arrears. Thirdly, there must be breach of some other condition of the mortgage. But right of 101 must be made fulfilled before taking consideration of one of the right of 103. However, if the mortgagor sells the land before the right of sale arise and become exercisable, it just means that he is transferring the right he has on the land to the purchaser. And also, when he tries to sell the land, when it has arisen and it has not become exercisable, then the mortgagor may set aside the sale if the purchaser is aware of the mortgage, in the case of Chukwuma. But when both powers have arose, the right of have arisen and it becomes exercisable, the mortgagor will only rely on equity to protect their position of obtaining best price, which will be reasonably obtained. Standard Chartered Bank, but when both powers have arisen, the mortgagor will only rely on equity, which, as indicator of Standard Chartered Bank, states that the mortgagor will have to stand in the position of obtaining the best price. Mortgagor may also apply to sell the property in court by virtue of Section 91 of the LPA. In conclusion, I will conclude with saying that the right of sale will be exercisable only and only when Section 101 of LPA completely made fulfilled. Brendan might have exclusion, may have agreement in the mortgage that right of sale cannot be exercised. Then that will exclude him. Without that, Tough Bank can exercise their right of sale. I will tell my manager, Ms. Putri, to check the mortgage. If the mortgage is indeed, then the right of sale will be exercised. If there is no agreement of not exercising right of sale, then it will be exercised. Thank you so much.